Hello, everyone. This is Mike Harrington. I'm one of the attorneys here at North Carolina who is part of our labor and employment group. I want to thank you very much for joining us today. Today we have almost 100 participants listening in the webinar. As usual, if you have any colleagues you think that might benefit from hearing this webinar, it will be posted after our recording today, and you can get that on our website. All callers will be in listen-only mode. If you have any questions during the presentation, you can write them in the questions box on your webinar toolbar, and we'll answer them at the end of the presentation. At the end of today's presentation, all participants will receive an email from Jackie Rowe with the PowerPoint presentation attached and an attendance certificate in case you need that. So thanks again for joining. We're going to wait just one more minute because we have people still signing on, and then we will get started. Just so you know, our next webinar presentation will be held on May 12th. It will be presented by my colleague, Rachel Faye Smith, who will be presenting on hardship withdrawals from plans, ERISA plans. Okay, why don't we get started, and as people sign on, they can jump in. So today's topic is definitely a very interesting topic and timely. If you had asked me 10 years ago, or certainly 20 years ago when I started practicing, whether I would be presenting on this topic, I would have said absolutely not. But here we are today in 2017 discussing the reality of being concerned about people smoking marijuana. And obviously we're having this increasing concern because of the prevalence of marijuana being socially acceptable. Certainly many states have adopted it for medical purposes, and a growing number of states are considering it for recreation. So when it comes to popularity, okay, hold on. Marijuana happens to be a fairly popular drug with over 18 million current users, making up about 80% of the total of all drug users. So it's pretty popular and maybe pretty accessible, but it is illegal. And this becomes a very important point. It is illegal under federal law. It is on Schedule 1 of the Controlled Substance Act. And so from a lawyer's perspective, what's interesting is you have states who are making the use of marijuana legal, but the federal government continues to maintain it as an illegal substance. And I do not expect that to change under the current administration. Now, under President Obama's administration in 2013, when it became recognized that states were beginning to go in a different direction with regard to marijuana, the U.S. attorney at the time came out with a declaration of what his view about enforcement would be. And generally speaking, he said that he would be taking a hands-off enforcement with regard to states that have decriminalized marijuana, but outlined certain parameters where the federal government would still be active in enforcing the federal law, even in states where it was legalized. I suspect that this hands-off approach under our Attorney General, Jeff Sessions, will not be followed. He hasn't made any formal declaration of that yet, but it would not surprise me if we hear about that shortly. So in terms of the sort of state of the union right now, we have 25 states recognizing medical marijuana, Connecticut and Massachusetts being 2 of those 25. And we have a number of states that have recreational marijuana. And actually, as of last year, Massachusetts passed a referendum. They should be added to that. Certain states are currently debating recreational marijuana. Rhode Island, I believe, is currently undertaking that question. And Connecticut, we had a bill pending, but as of yesterday, it was reported that the bill looked like it no longer had enough support this year. That being said, I think this still remains a very significant topic for HR folks to be aware of. Even though it may not pass in Connecticut this year, I think recreational marijuana may be on the horizon at some future point. And nevertheless, given Connecticut being a small state with our neighbors to the north, east, and west potentially considering legal recreational marijuana, it could well be impacting our workforces. So just to review where we are in Connecticut, effective October of 2012, we did pass an act permitting medical marijuana. It passed by fairly good margins, and previously it had passed the legislature, but it was vetoed by then Governor Rell. So again, it makes me think that if recreational marijuana is not passed in this legislative session, it may well have some potential in a future legislative session. As Governor Malloy stated, the objective was to provide relief to those with severe medical issues. Now, when we look at the Connecticut law, it's important to understand a couple of different terms. What the Connecticut law permits is that qualifying patients with written certification may use marijuana for palliative care. And so it's important to understand, first off, where do you get a written certification? So a qualifying patient must have a debilitating medical condition. The physician must explain the risks and benefits of the use of marijuana, and in the physician's opinion, it must be for the best interest of the patient, and the physician cannot have any financial interest in a licensed dispensary of marijuana. So if they get this written certification within these guidelines, they may access marijuana. To be a qualifying patient, the individual must be 18 years or older, a resident of Connecticut, again, diagnosed by a physician as having one of the qualifying debilitating conditions, and it cannot include any inmates in a correction facility. Now, some of these conditions include cancer, glaucoma, epilepsy, Crohn's disease. There's 22 in total, and the law contemplates that this list will be periodically reviewed by a group of medical professionals, and it may expand or potentially contract over time. Our law also gives protection to primary caregivers. So you need to keep in mind it's not just the qualifying patient, but you may have someone in your workforce who is considered a primary caregiver, and they will be protected under this statute as well. They have to be over 18 years of age. They have to be responsible for managing the well-being of a qualifying patient, and satisfy the other requirements, such as you can only be a primary caregiver to only one qualifying patient. So getting to the heart of the matter for our call today, the Connecticut statute provides protection to both the qualifying patient and to the primary caregiver. Employers may not refuse to hire, fire, penalize, or otherwise threaten an employee solely on the basis of being either a qualifying patient or a primary caregiver. There's a few exceptions. One is if the employer somehow is bound by federal law or federal funding such that there's some provision in those laws or regulations or qualified funding not to hire such a person, then there may be an exception to the statute. I know in my practice I have not encountered any such specific law that would prohibit an entity from employing a qualified patient or caregiver. In terms of who are employers, some statutes, as you know, have different thresholds. This one has a very low threshold, any person engaging in business who has one or more employees. So basically all employers, and it includes both public sector and the private sector. One thing to appreciate is the confidentiality that goes along with this statute, that someone's status as a qualifying patient is considered to be confidential. For those of you listening who are subject to the Freedom of Information Act, any documentation regarding an individual's status would not be subject to disclosure under the Freedom of Information Act. And although an employer can certainly ask to verify an employee's status, they should not make that document public to any individual, except for probably folks in HR who would need to know that for very specific reasons. Just how someone might go about getting medical marijuana. In the statute provides for licensed producers and licensed dispensaries. They are beginning to begin operations, I know, in the state of Connecticut. I think there's a couple that are up and running, and so there certainly is a source for individuals to receive marijuana if they are certified. Now, simply because an employer cannot refuse to hire someone because they are a qualified patient does not mean that an employer must allow someone to use medical marijuana even at work. The statute has specific prohibitions about when where medical marijuana is not to be allowed or may not be allowed, and the workplace is certainly one of those. And the other thing that employers have the ability to act on, which may be easier said than done, is that the employer can still prohibit the use of marijuana or intoxicating substances during work hours, or prohibiting people from coming to work under the influence of those substances during work hours. And we'll talk about the challenges that presents in terms of discerning whether someone is in fact under the influence of under medical marijuana or not. So in terms of open questions for HR, just based on the Connecticut statute, obviously for employers who have workforces who are telecommuting, this may be more difficult to monitor and enforce any policies you might have if people are working at home, and you might give some consideration to that in your policies if you do have a fair number of telemarketers. Certainly folks who work outside the general office, such as outside salespeople, may present also challenges. In terms of zero tolerance, where an employer has a policy that says under no circumstances may any of its employees use marijuana or other illegal substances, folks in Connecticut have a little bit of a limitation on having those policies. Those policies now must recognize that if someone is properly certified or has a written certification and is authorized under the Connecticut statute to use medical marijuana, that they are exempt from being fired or suffer other penalties simply for using medical marijuana. But again, going back to our earlier slide, if someone reports to work under the influence or is using at work, those are bases under Connecticut law for taking action. Now, there are other states, and you may read about this in the news or see different articles, and if you are an employer that operates in different states, there are states that even where medical marijuana is legal, either recreationally or for medical purposes, employers can have comprehensive zero-tolerance policies. There is a noted case that was decided in 2015 involving Dish Networks. Dish Networks employed an individual who was severely disabled. He was a quadriplegic individual, and he used medical marijuana. There was no evidence that he was under the influence while at work or that his work was any way impacted him. To the contrary, the record reflected that he was actually an outstanding employee. However, the employer somehow learned that this individual had been using medical marijuana while off duty and terminated him for that. And the question that went all the way up to the Colorado Supreme Court was whether that was permitted. And the Supreme Court said yes, their particular statute, unlike Connecticut, did not provide any protection for a user of medical marijuana when it comes to their employment. And because use of medical marijuana remains illegal under federal law, that the employer was free to do so. And we'll talk in a few minutes about some of the factors about whether you want to continue to, whether you would want to have that policy to the greatest extent possible. And in Connecticut, you could, with a limited exception for medical marijuana users, or not. And one of the final open questions is, what about employees who request a reasonable accommodation to use medical marijuana during breaks or for some adjustment in their work schedule in order to use medical marijuana? And this is truly an open question. Obviously, under federal law, because marijuana is illegal, the Americans with Disabilities Act would not require any form of reasonable accommodation for the use of marijuana. In state law, I'm not sure how the CHRO and the courts would deal with it. Our statute does recognize that there is no entitlement to use it during work. So depending on the specific nature of the requested accommodation, there may be some guidance provided by the statute, but for some accommodation that may entail using outside of work, but somehow impacting work, such as if someone wanted to, if it was prescribed to be used first thing in the morning and they wanted to start their workday later so they would not be coming into work under the influence, I think it is an open question whether the CHRO or a Connecticut court would consider that to be a reasonable accommodation. As with any reasonable accommodation request, it depends largely on the circumstances. How would that impact the workplace? Would the person truly have enough time to be outside of being under the influence of the marijuana? And these are certain questions that you would have to engage in with the employee and with appropriate medical providers. Now, as I mentioned, when we first put out this webinar topic, it looked like there was a real shot at the possibility of recreational marijuana becoming legal in Connecticut. I think based on the report this week, that's less so. But our friends to the north do have recreational marijuana. It took them a while to get there. This chronology gives you a sense of Massachusetts, much like Connecticut, historically had not been at all supportive of marijuana. It began with its legalization of medical marijuana the same year we did, in 2012. And then last year in a referendum vote, there was passage of it, and the legislature now is working to figure out how to implement that mandate, or that possibility or permission, I guess, for using medical marijuana. The basics in the federal and the Massachusetts statute are that 21 individuals who are 21 years old or older can use, they can possess limited amounts of marijuana outside the house. They can possess greater amounts within their house. There are certain things that remain illegal, and Massachusetts statutes specifically addresses the question we were just talking about, whether employers are required or permitted to accommodate marijuana use in the workplace, and they are not. But again, our statute doesn't specifically address that, other than actual use in the workplace. Now let's just spend a couple minutes talking about the cost. I mean, this should come as no surprise that when employees abuse drugs, it comes at a cost not only to society but to employers. Certainly absenteeism increases, less productivity, potential concerns for theft and damage to equipment. So this is a real issue that employers have to face. When we were talking about how do you know if someone's under the influence, well, you can see there's certainly certain aspects of the workforce that have greater risks of drug use or drug abuse and alcohol abuse than others. Depending on what industry you might be in, you may be able to relate to some of these statistics. So how do you know if someone's under the influence of marijuana? There are certain indicators. What's challenging about marijuana as opposed to alcohol will normally leave the system certainly within a certain number of hours. And so if I have a glass of wine on Sunday, it is not likely to show up in my system on Monday. That is not true of marijuana. Marijuana can remain detectable in an individual's system for days and potentially weeks after consumption. And that's not to say that they are under the influence of the marijuana. It's just that if you were to test for it, that the test might come up positive. I know from talking to certain individuals in the testing field, they are continually working to develop better testing mechanisms for getting a higher degree of certainty with regard to marijuana and usage. This is especially true up in Massachusetts and other states that permit recreational use. Each of those statutes does prohibit the driving of a motor vehicle under the influence of marijuana. And so the question is, at what point are you deemed to be under the influence of marijuana? And they are working, that's part of what the Massachusetts legislature is working at, is to come up with specific guidance in terms of what level of presence in the system would constitute legally being under the influence of marijuana. You certainly know from alcohol that there is some variance and actually been some current revisions down of an acceptable blood alcohol level. And right now, I know Massachusetts is working to establish those standards for marijuana. But as general rule, these are some of the indicators of whether someone may be under the influence of marijuana. They may act with great, as if they are anxious, have hallucinations, red eyes, certainly a certain smell, potentially increased appetite. And so these are things that, when we get to talking about what employers should be doing, you want to include as part of your training for your supervisors, the ability to potentially recognize when someone's under the influence of marijuana, just as much as you train, hopefully, for your supervisors to discern when someone may be under the influence of alcohol. Now, how would an employer go about testing? There obviously is multiple sciences available for our employer to test. Connecticut, we'll talk about the Connecticut statute. Our statute only focuses on urinalysis, although I think members of our Department of Labor believe that it may extend to other means of testing, although the statute does specifically reference urinalysis. And urine remains still the most prevalent method for testing. It's not very invasive, it's fairly accurate, and it's of modest cost. But obviously there are other forms of testing that are available, and depending where you're operating, you may utilize some of these different tests. Here in Connecticut, it's very important to appreciate that we have a statute that limits our ability to test. You can test in 3 general circumstances. Pre-employment, before someone's hired, and it should be noted that if someone's been working with you, let's say on a part-time basis, for within the last 12 months, and they apply for a full-time position, and if you're a workplace that only tests full-time employers, you would not be able to test that individual because they had been working for you in the prior 12 months. So it really has to be new hires that you are testing. I personally wonder about the value of a pre-hire test, although it's quite prevalent in the workplace, especially here in Connecticut, because someone, if they know they're going to be tested on a certain day, you would hope they would have the wherewithal to clean themselves out of any substances prior to testing. That's not always true. So I think of sometimes pre-employment testing as an intellect test more than some other basis. But pre-employment is certainly one basis for testing. You can certainly test when you have a reasonable suspicion that someone is currently under the influence of drugs or alcohol. And this goes to the point of training your supervisors. What should they be looking for? Certainly when you are going to ask someone to be tested under this basis, you want to have folks who could clearly articulate why they thought someone was presently under the influence of drugs or alcohol, which led to the request. This does not mean that when you hear there was a party on Saturday night that some of your employees might have attended, that you can test them on Monday. If they come into work looking fine, acting fine, that would not be a reason to test them. Similarly, unlike in some states, so for those employers who are listening who operate in other states, Connecticut does not allow testing simply because someone has an accident. If someone has an accident with a car or a piece of equipment, and when you go over to question them about the accident, they have signs of being under the influence of drugs or alcohol, such as slurred speech, red eyes, anxious behavior, so forth and so on, that's fine. But the reason for the testing would not be because of the accident, would be because of those observations made that would lead a reasonable person to believe that individual is under the influence of drugs or alcohol. And then finally, you can have follow-up testing. So after a positive testing, you can have a follow-up. But you could also have random testing if you have individuals working in a safety-sensitive position approved by the Connecticut Department of Labor. So the Department of Labor has identified positions that are likely to be approved as safety-sensitive, but you can't simply assume because you're a pole climber or an electrician that you can do random testing. You have to apply to the Department of Labor to get that approval. And the other thing I'd like to just note is random means random. It's not, gee, Mike is acting a little funny today. I think we should test him in our random program. That would not be random. The best programs are ones that are administered by a third party who will call up an employer and say, today is Mike's day for testing, send him down. So again, for those of you who have federal DOT drivers, DOT-approved drivers would be very familiar with a random test. But in Connecticut, if you don't satisfy one of those bases for testing, you cannot test. But I think a lot of employers have to ask themselves whether they need to test. You know, if someone's not doing their job, if they're acting in an inappropriate way at the workplace, employers might first ask themselves, is it important for me to know whether this behavior is drug-induced, alcohol-induced, or not, or is the behavior simply unacceptable, and regardless of the cause of the behavior, can I just take action based on the behavior itself? You know, possibly if you're in a union environment and you want to make sure you meet a just cause standard, you may think about testing, but I think in a lot of circumstances an employer would be free to act simply based on the demonstrative behavior as opposed to sending an individual for testing. I'll just mention this. Hopefully it's words that don't need to be said, but I've had a couple situations where employers have sort of made this mistake where they have believed someone to be under the influence of drugs or alcohol and have sent an individual home and sent them out to the parking lot to get their car and to go home. If you think someone's under the influence of drugs or alcohol, be sure that you treat them as such and that you either call them a cab, an Uber, or you have an individual take them home. I've had employers ask me, well, what do you do if the individual insists on driving home? You know, my recommendation is that you inform them that you do believe they may be under the influence of drugs or alcohol and that you do believe they are not fit to drive. And if they drive anyways, you will report the matter to the police. The two instances that I can think of that I had to give that advice, the individual then capitulated and someone drove them home. Actually, two people drove, one in their car, one in a follow-up car, so that the individual could have their car, you know, the next morning. But you want to make sure you act consistently with your belief if you truly do believe that person is unfit to work because they're under the influence, then they are assumably unfit to drive. So what should an employer be doing in this time? First and foremost, look at your existing policies. Ask yourself, what type of policy do you want to have? Do you want to have a zero tolerance policy to the greatest extent permitted by law? Do you want to have a policy that, certainly in Connecticut, you have to have a policy that limits, you know, or permits the legal use of medical marijuana, and that you can't fire someone simply for being a user of medical marijuana, but you can certainly be very specific in your policy to say that even if you are a qualified patient with written certification, you may not come to work under the influence, and you may not use at work if those are the decisions you're going to make. If you are in a state that would permit complete zero tolerance, you have to ask yourself whether that is where your organization wants to be. Certainly from creating a drug-free work environment and trying to maintain a healthy workforce, that would be a good approach. There's some interesting articles out about ski resorts in Colorado who first tried to go with a complete drug-free, zero-tolerance kind of a work environment and found that they were then struggling to fill some of their positions. So depending on where you are and where you are recruiting from, you may run into this. And certainly as society has a greater tolerance for marijuana, that may also change in the future, where if it's not impacting recruitment now, it may do so in the future. So something to certainly pay attention to. You certainly want to educate your employees and supervisors, both in terms of whatever your policy is, but also in terms of recognizing behaviors that should be brought to management's attention if they are observed. Through education, maybe you will get compliance at an earlier stage, and certainly you'll have supervisors who then can be attentive to what should they be documenting, what should they be looking for in making a call as to whether an individual should be sent home and how they should go about that, and whether that individual should be tested or not. Then, and then the third point I've already made, you want to make sure you're very careful to act in a consistent manner so that you know, you're not tripping up over yourself where take a position that you believe the person's under the influence and can't work, but then directed to drive themselves home. So for the time being, that's where we are in Connecticut. I think we'll have to wait and see whether recreational marijuana will be coming down the pike. But nevertheless, knowing that Maine, Massachusetts, and potentially some of other states in New England are going in the direction of recreational marijuana, I think this is certainly a good time for employers to look at their policies and ensure that they have thought this through and come to a place that they are comfortable with. With that, if anybody has any questions, I'd be glad to answer them. Okay, so the question is, isn't it OSHA law now that it's all states for no post-accident drug testing? No, I mean, OSHA, I can't say that I've heard that from OSHA, that, OSHA prohibits post-accident drug testing, but certainly certain states, it is permissive to do post-accident testing, such as I believe Massachusetts is one of those states, but Connecticut is not. And so I think it continues to be on a state-by-state basis. People are asking whether they can get a copy of this webinar presentation. Yes, it's going to be emailed to you by Jackie Rowe. Jackie is out today, so she will be doing that early next week. So look for that next week. If an applicant fails a pre-employment drug test and then states they have a medical marijuana card, can we rescind the job offer if the policy dictates a public result leads to rescind? I think this is one of the open issues in Connecticut. We begin with looking at the Connecticut statute, which says an employer may not make a decision to hire or fire an individual simply for being a qualified patient. And so if someone comes to you, even after you've tested them, and does demonstrate that they are a qualified user, and because marijuana does have this lingering presence in a system, I think that employer may be at some risk for violating the Connecticut statute. Certainly, if someone comes to work under the influence, that's a different matter. But again, this is where in Connecticut having a zero tolerance policy, I think, is going to present some issues for employers when the individual who tests positive is subject, got the written certification for medical marijuana. But it's an open issue. It hasn't been litigated yet. That's just the best advice I can give presently, given the way the statute is written. Next question. Yes, well, what I was told from someone, the question is, doesn't marijuana stay in the system for up to 30 days or longer? And so what I was told by someone in the testing field is it really depends on a lot of variables. It depends on the type of consumption. Was it smoked? Was it consumed in some food product? Was it in an oil? The person's body mass plays a role. But the point certainly is that marijuana has a lingering presence in the system. But they are getting better about testing, and I forget, honestly, the medical term, sort of the strength of the presence, which would be an indicator in terms of being under the influence or not. So I think that technology is developing rapidly because states need it to enforce driving requirements. Would you treat alcohol or other legal drugs any differently from a policy perspective? I think that's a question for employers. So certainly, one could imagine if you said, I'm not going to hire anyone who consumes alcohol, that would be have a huge impact on recruiting. But you certainly, in Connecticut, except for the medical marijuana, you could certainly take that approach. And in fact, employers around the country, certain ones do take that approach, such as Dish Network, where they fired that individual who was a good employee and did use legally under state law, but they had this zero tolerance policy. I think you have to ask yourself, and management has to have a serious conversation about what's really important to us. Is it important that the employees simply not report to work under the influence? Is it important that we not have any employees ever use, even during their vacation or during their non-work days? And how might that impact, your ability to staff your company? Those are all the questions I think you need to first ask before you do that. But do recognize, I know I've said this a couple times, but Connecticut has that specific protection for people who use medical marijuana, and I think if they do not report to work under the influence, simply having used off-duty, as long as it's within their prescription, I think the employer cannot take action against them. Is pre-employment testing permissible in states that allow recreational marijuana? It's hard to answer. There's 8 different states. I'm not familiar with all of their laws. As a general rule, to the degree I'm aware, most states do allow for pre-employment testing, and there are certainly states that do allow employers, Massachusetts being one of them, by the way, that if an individual tests positive on a pre-employment test, regardless of whether they used legally, either for recreational or medical, and I'm speaking just for Massachusetts, that the employer can then make a decision not to hire them. Again, in Connecticut, we have a statute that does speak to, using medical marijuana, but other states don't. So this may be a challenge for some employers who operate in multiple states and are trying to come up with consistent rules, because right now there is a fair amount of variety happening on the state level. Is the employer responsible for verifying the medical certification? Whether you're responsible or not, the way I would look at it is you should. I would not simply take an employee's word for it. In terms of being a reasonable employer and not wanting to get caught up with a negligent hiring claim or a negligent retention claim, I think taking a fairly easy step of verifying is appropriate. And it also might give you some clarity about when is the usage, because there may be some conversation with the employee about when they come back to work or them needing some accommodation, and by making sure you have the correct information, that'll make the conversation more valuable. What about current employees who become a qualified patient and want to get medical marijuana cards? However, his or her position entails work out in the community, includes driving clients. Well, this is really no different. When I answer this question, I sort of think about any prescription drug. Let's imagine someone has some ailment and they take a pretty powerful drug, and the doctor says that while you're taking this drug, you cannot drive. So the question is that individual still qualified? If what we're talking about is a person who uses medical marijuana, but the doctor opines that as long as they don't use it more than 10 hours before they come to work, then there should be no problem with driving. I mean, it really depends on what the doctor is going to give you in terms of an opinion about whether that individual continues to be qualified or not. I would treat this very similar to how employers treat a lot of other medical conditions, where you provide the doctor with a job description. You tell them very clearly what the expectations are, and then you seek an opinion about whether that individual is qualified or not. If you feel like the doctor does not give you a thorough opinion or a well-reasoned opinion, then I would take the step of seeking out your own medical opinion on that question before you would do that. And certainly, if the employee is going to be entrusted not only with a company car but with clients, you want to make sure you take those steps. So I don't think it's an absolute mandate that they couldn't. I think it's going to very much depend on the facts of that particular case. Could an employer refuse to hire based on recreational use if the state did not legalize recreational use? Certainly. I mean, then they're engaging in illegal activity. But even where it is legalized, there is, I believe, no state that's legalized recreational use has tolerated, or prohibited employers from being able to use that as a factor in their hiring decision. So, so right now, recreational use can certainly be something that if the person tests positive, you can, and it's because they used recreationally, then you can take action. Given the varied potency depending on the type of marijuana and whether edible, smoked, etc., it's difficult to know how long after ingestion a person will remain intoxicated. Can that form the basis to decline employment on safety-sensitive positions with medical marijuana? I think, honestly, I would want to get a little better opinion from a doctor on that point. And mainly because the statute does have this very specific protection for someone being qualified. And again, I don't know how often they're using. If the prescription is I only use when I'm feeling nausea after chemotherapy and I'm going to take a couple days after chemotherapy and my chemotherapy is only one day a week and I do it on Friday, then I think that situation presents a very low risk, but there could be situations with higher risk. And so I think you want to take it, when it comes to medical marijuana, on a case-by-case basis and really get the relevant facts for that particular case. Can you test for reasonable suspicion in Connecticut? Yes. As I mentioned, that is one of the bases for testing that is permitted in Connecticut, but you have to make sure you have an articulable reason why you believe the person is potentially under the influence of drugs or alcohol that could negatively affect the work. So, it has to be, as you're looking at that person, and I tend to recommend that 2 or more people make the observation, you'd be able to say, we both saw slurred speech, we both smelled alcohol, or marijuana, we both found the person to be unusually anxious, whatever it is. But yes, you can, if the facts support it. Should the behavior be tracked and documented first? Absolutely. So the person making the observation, and as I mentioned, should be persons if you can, should document what they observed, which led them to believe that that person was under the influence of drugs or alcohol. Because at some future date, if that decision was ever challenged, it may be difficult for that person to remember all of the particular details that led them to that belief. So that's why I think having that second person to corroborate and then documenting it are 2 very good practices. I think that's all of our questions. I really appreciate everyone's participation. If you have any other questions, by all means, feel free to reach out, and hopefully you'll join us in May when Rachel will be talking about hardship withdrawals. Oh, did I miss one?
No, you just.
Oh, okay. 2 more in. Let's see. we just stopped our blanket post-accident drug testing policy due to the new OSHA rules and regulations which prohibit automatic drug testing after an accident. So again, I'd have to double check that. I can tell you it's illegal in Connecticut to drug test after an accident. There were other states that allowed it. I'd be curious where the rule came from OSHA, and I'd be glad to talk to you offline about that further. Just reach out to contact me, and I'd be glad to look at that more specifically when it comes to OSHA. And the last question is, can we inquire into the reason why someone has a medical marijuana card or the frequency of use, or would that violate the ADA? It wouldn't necessarily violate the, I mean, I guess it could violate the ADA, but it's not necessary. I mean, if you've got a physician who has certified that this person has one of these debilitating conditions as permitted by the Connecticut statute, that's all you need to know. It's really similar to ADA or disability law or FMLA law that says if a doctor opines that someone has a serious health condition, then that's all you need to know. You don't need to get into the particulars. And as an employer, this is certainly an area where ignorance is sometimes bliss, that you don't know the particular medical details. Well, what you would want to know are the things that would affect your business, such as, what are the lingering effects? How long might someone be impaired after usage? How frequently do they have to use? Do they have to use during your typical work hours? Those are the questions you may want to pursue in greater detail from the treating physician. And if you feel like you don't get good answers, you may have to seek out your own medical opinion before you allow someone to work, especially in a safety-sensitive position, knowing that they are, a qualified patient. Okay? Have a great weekend, everyone. Thank you for joining us.